I solemnly declare that I will perform my duties and exercise my powers as judge honorably, faithfully, impartially, and conscientiously.
I now give the floor to the agent of Equatorial Guinea, His Excellency Mr. Carmelo Mbono Nka. You have the floor, sir.
Friends, welcome to the Manuscript Papua YouTube channel. Hi everyone, thank you for joining us here at Manuscript Papua. Analogi dan relevansi. Kasus Guinea Khatulistiwa versus Prancis, dan kita mengaitkan kasus ini dengan logika andaikan Papua juga menggugat Indonesia. Kasus Guinea Khatulistiwa versus Prancis ini melibatkan wakil presiden Guinea Khatulistiwa dengan dugaan korupsi lintas negara hingga penyitaan mansion mewah miliknya di Paris. Kali ini kita akan menambahkan perspektif yang menarik. Apa jadinya jika Papua suatu saat merdeka? Apakah mereka juga bisa menggugat Indonesia atau negara asing lainnya atas dasar eksploitasi sumber daya alam seperti tambang emas Freeport? Yuk, kita bahas langkah demi langkah. Kita mulai dari awal kasus siapa yang terlibat. Tokoh utama dalam kasus ini adalah Teodoro Nguema Obiang Mangue, wakil presiden Guinea Khatulistiwa. Ia juga adalah anak presiden Guinea Khatulistiwa yang sudah berkuasa lebih dari 40 tahun. Teodoro diketahui hidup sangat mewah. Ia membeli mobil sport, jam berlian, dan terutama sebuah mansion super mewah di Paris, Prancis. Masalah muncul ketika muncul dugaan bahwa uang yang digunakan berasal dari dana publik negaranya, artinya uang rakyat. Kenapa Prancis turun tangan? Prancis mulai menyelidiki Teodoro karena 1. Properti mewah itu berada di Paris. Karena itu, Prancis berwenang menyelidiki kejahatan apapun yang terjadi di wilayahnya, meskipun pelakunya warga asing. 2. Diduga pencucian uang hasil korupsi. Prancis menilai mansion dan aset lain itu dibeli dengan uang yang disalahgunakan, lalu dicuci agar terlihat legal. 3. Laporan dari LSM Internasional. Organisasi seperti Transparency International melaporkan gaya hidup pejabat Afrika yang menyembunyikan hasil korupsi di Eropa. Setelah penyelidikan, pengadilan Prancis memutuskan bahwa mansion itu bukan milik negara, melainkan hasil korupsi pribadi, lalu menyitanya. Pemerintah Guinea Khatulistiwa tak tinggal diam. Mereka mengklaim mansion itu bukan milik pribadi, tapi milik negara, dan digunakan untuk fungsi diplomatik sehingga tidak boleh disita menurut hukum internasional. Tapi pada tahun 2020, Mahkamah Internasional menolak klaim itu. Alasannya, mansion itu tidak didaftarkan secara resmi sebagai fasilitas diplomatik, jadi tidak mendapat perlindungan hukum diplomatik. Tahun 2022, Guinea Khatulistiwa menggugat lagi. Kali ini dengan pendekatan berbeda. Mereka menggunakan Konvensi PBB melawan korupsi, UNCAC, dan menuduh Prancis menyita aset negara secara tidak sah dan menghalangi kerjasama dalam pemulihan aset. Lalu, pada Juli 2025, muncul laporan bahwa Prancis mengganti kunci mansion dan masuk tanpa izin. Guinea Khatulistiwa pun meminta Mahkamah Internasional untuk 1. Menghentikan segala tindakan Prancis, 2. Mencegah penjualan mansion, 3. Memberi mereka akses penuh ke properti. Sidang terbuka digelar pada 15 Juli 2025 di Den Haag, Belanda. Dan video yang Anda ikuti saat ini adalah proses sidang tersebut. Sekarang, mari kita bayangkan, bagaimana jika suatu saat Papua merdeka? Bisakah Papua menggugat Indonesia atau negara asing karena selama ini mengambil kekayaan alam mereka, seperti emas dari PT Freeport? Jawabannya, secara teori, bisa. Tapi ada syarat besar. Apa saja syaratnya? 1. Harus jadi negara merdeka dan diakui dunia. Papua harus menjadi negara yang berdaulat penuh, diakui oleh PBB dan komunitas internasional. Tanpa ini, mereka tidak bisa menggugat di Mahkamah Internasional. 2. Harus ada dasar hukum internasional, misalnya, pelanggaran hak atas kekayaan alam, hak masyarakat adat, atau eksploitasi tanpa persetujuan. 3. Harus punya bukti kuat. Papua harus membuktikan bahwa sumber daya mereka diambil tanpa izin atau kompensasi adil, dan rakyatnya dirugikan secara nyata. Sama seperti Guinea Khatulistiwa menuntut pengembalian aset, Papua, jika merdeka, bisa menuntut pengembalian kekayaan atau kompensasi atas eksploitasi sumber daya alam. Tapi keduanya butuh status hukum internasional, bukti kuat, dan jalur hukum yang tepat. Kasus Guinea Khatulistiwa versus Prancis adalah contoh nyata bagaimana sengketa antar negara soal aset, korupsi, dan kekuasaan bisa dibawa ke Mahkamah Internasional. Jika Papua suatu saat merdeka, kasus ini bisa menjadi preseden yang menunjukkan bahwa negara baru pun punya hak menuntut keadilan, asalkan melalui jalur hukum internasional. Dan orang Papua sendiri harus paham jalur-jalurnya. Friends, don't forget to leave a positive comment. Warm greetings from Manuscript Papua.
Manuscript Papua.
Please be seated. Good morning. The sitting is open. Initially, the court was planning to first hold a sitting to enable the newly elected member of the court, Judge Mahmoud Daifala Humud from Jordan, to make his solemn declaration pursuant to Article 20 of the statute for the court. This was announced through a press release of the court issued on 8 July 2025. Unfortunately, Judge Humud was informed yesterday of the sudden demise of a close relative and had to leave The Hague immediately. The public sitting for the installation of our new colleague is therefore postponed and will take place at a later date to be announced in due course. On behalf of the court, I wish to present my condolences to Judge Humud and to express to him and his family my profound sympathy for their loss. Today, the court thus meets under Article 74, Paragraph 3 of the Rules of Court to hear the argument of the parties on the request for the indication of provisional measures submitted by the Republic of Equatorial Guinea in the case concerning the request relating to the return of property confiscated in criminal proceedings, Equatorial Guinea versus France. I note that, in addition to interpretation from and into the court's two official languages, English and French, interpretation from and into Spanish is available in accordance with specific arrangements made at the request of Equatorial Guinea. As the court does not include upon the bench a judge of the nationality of Equatorial Guinea, the applicant availed itself of the right under Article 31, Paragraph 2 of the statute to choose a judge ad hoc to sit in the case. It chose Mr. Tawhid Olfemi Elias. Article 20 of the statute provides that every member of the court shall, before taking up his duties, make a solemn declaration in open court that he will exercise his powers impartially and conscientiously. Pursuant to Article 31, Paragraph 6 of the statute, that same provision applies to judges ad hoc. Before inviting Judge Elias to make his solemn declaration, I shall first, in accordance with custom, say a few words about his career and qualifications. Mr. Elias, who is of Nigerian nationality, studied law at the University of Oxford before obtaining a master's in international law at the University of Cambridge and a PhD in international law at the University of London. In his wide-ranging and illustrious career in the legal field, he has combined judicial appointments with academic positions and an array of experience as an international civil servant. He is currently President and Judge at the Administrative Tribunal of the Fund for International Development of the Organization of the Petroleum Exporting Countries, President and Judge of the OPEC Appeals Tribunal, and Chairman and Judge at the Islamic Development Bank Administrative Tribunal. He has previously served as Judge for Staff Appeals at the Special Tribunal for Lebanon. Mr. Elias is also a visiting professor in international law at Queen's Mary University of London and has lectured in law at King's College London, the University of Buckingham, the University of Amsterdam, and the Diplomatic Academy of Vienna. He was previously registrar at the International Residual Mechanism for Criminal Tribunals, legal advisor of the Organization for the Prohibition of Chemical Weapons, executive secretary of the World Bank Administrative Tribunal, and special assistant to the executive secretary of the United Nations Compensation Commission. Mr. Elias is a member of the panel of arbitrators of the Asian African Legal Consultative Organization and a member of the Institut du Droit International. He has written extensively on many areas of international law, from the law of treaties to international administrative law. I shall now invite Mr. Elias to make the solemn declaration prescribed by the statute, and I request all those present to rise.
I solemnly declare that I will perform my duties and exercise my powers as judge honorably, faithfully, impartially, and conscientiously.
I take note of the solemn declaration made by Judge Elias and declare him duly installed as Judge ad hoc in the present case. I shall now recall the principal steps of the procedure in the present case. On 29 September 2022, the government of Equatorial Guinea filed in the Registry of the Court an application instituting proceedings against the French Republic concerning the alleged violation by France of its obligations under the United Nations Convention Against Corruption of 31 October 2003. In particular, the applicant contends that the respondent is under an obligation to return to Equatorial Guinea certain property in France which was confiscated by decision of the French courts, including a building located at 4042 Avenue Foch in Paris. To found the jurisdiction of the court, the applicant invokes Article 36, Paragraph 1 of the Statute of the Court, read in conjunction with Article 66 of the Convention Against Corruption. Together with the application, Equatorial Guinea submitted a request for the indication of provisional measures. Following receipt of a communication from Equatorial Guinea dated 19 October 2022, informing the court of the applicant's decision to withdraw its request, the President of the Court issued an order dated 21 October 2022, placing on record the withdrawal by Equatorial Guinea of its request for the indication of provisional measures. On 3 July 2025, Equatorial Guinea submitted a new request for the indication of provisional measures pursuant to Article 41 of the Statute of the Court and Articles 73, 74, and 75 of the Rules of Court. In particular, it states that on 27 May 2025, the French Agency for the Management and Recovery of Seized and Confiscated Assets filed an application to the President of the Paris Tribunal Judiciaire in which it requested the appointment of a court enforcement officer who could enter the building at 42 Avenue Foch, whose return is sought by Equatorial Guinea on the basis of the Convention Against Corruption. Equatorial Guinea maintains that on 18 June 2025, members of the French Judicial Police and the National Police, as well as officials from the Agency for the Management and Recovery of Seized and Confiscated Assets and other auxiliary personnel, entered the building in the absence of its occupants and without informing them in advance, and proceeded to change the locks of several of the building's doors. According to Equatorial Guinea, despite the request that it made to France to provide by no later than 27 June 2025 assurances of its commitment not to cause irreparable prejudice or to further aggravate the dispute or make it more difficult to resolve, France has failed to provide any such assurances. The Registrar will now read out the passage from the request specifying the provisional measures which the government of Equatorial Guinea is asking the court to indicate, pending a final judgment in the case. You have the floor, Mr. Registrar.
Merci, Monsieur le Président. Je cite Sur la base de l'ensemble des faits et des arguments exposés ci-dessus, la Guinée équatoriale prie la Cour d'indiquer, conformément à l'article 41 de son statut, les mesures conservatoires suivantes. A. La France doit prendre toutes les mesures nécessaires afin que l'immeuble ne soit pas mis en vente. B. La France doit garantir à la Guinée équatoriale un accès immédiat, complet et sans entrave à tout l'immeuble. C. La France doit s'abstenir de tout acte qui risquerait d'aggraver ou d'étendre le différend dont la Cour est saisie ou d'en rendre le règlement plus difficile. Fin de citation.
I thank the registrar. Immediately after the request for the indication of provision measures were filed, the registrar transmitted an original copy thereof to the government of France. According to Article 74, paragraph 1 of the Rules of Court, a request for the indication of provision measures shall have priority over all other cases. Paragraph 2 of the same article states that the court shall proceed to a decision on the request as a matter of urgency. This imperative must, however, be balanced with the need to fix a date for the oral proceedings in such a way as to afford the parties an opportunity to be represented at the hearings. Consequently, the parties were informed that the date for the opening of the oral proceedings, during which they could present their observations on the request for the indication of provision measures, have been fixed for Tuesday, 15 July 2025 at 10 a.m. I would now like to welcome the delegations of Equatorial Guinea and France. I note the presence before the court of the agent and counsel of both parties. This morning, the court will hear the single round of oral argument of Equatorial Guinea, which has submitted the request for the indication of provision measures. It will hear France this afternoon at 4 p.m. For the purpose of this single round of oral argument, each party will have available to it a 2-hour sitting. In this first sitting, Equatorial Guinea may avail itself of an extension beyond 12 noon today in view of the time taken up by these introductory remarks. Before giving the floor to the agent of Equatorial Guinea, I wish to draw the attention of the parties to practice direction 11, which states as follows, I quote, "In the oral pleadings on request for the indication of provision measures, parties should limit themselves to what is relevant to the criteria for the indication of provision measures as stipulated in the statute, rules, and jurisprudence of the court. They should not enter into the merits of the case beyond what is strictly necessary for that purpose." End of quote. I now give the floor to the agent of Equatorial Guinea, His Excellency, Mr. Carmelo Mbono Nka. You have the floor, sir.
Señor Presidente.
Mr. President, members of the court, it is an honor to appear before you once again as agent for the Republic of Equatorial Guinea. We are very grateful to the court for arranging this hearing at such short notice, given the urgency of the case. We also greet the French delegation. We fully appreciate how busy the court is, and we are again thankful for the court's attention, and we apologize for any inconvenience that we may have caused on your program. Unfortunately, France's actions left us no option but to approach the court in this way. It may be recalled that we had made a request for provisional measures at the start of this case in the year 2022. But we then withdrew this request in a spirit of good faith in this judicial process, and with the perspective of a possible negotiation between the parties, and with the hope that France would cease its behavior. Likewise, just 3 weeks ago, in our letters to the court dated the 24th of June 2025, we sought to avoid this proceeding by inviting France to give, by the 27th of June, guarantees undertaking not to adopt any irreversible measures. That letter was swiftly transmitted to France. That letter is in your folders. To our great regret, however, France failed to provide such guarantees after several days. Therefore, on the 3rd of July, we requested the corresponding provisional measures from the court. We reiterate our invitation to France today in the hope that France will give the necessary guarantees when it addresses the court this afternoon. Mr. President, as the court is aware, the matter before you is important and very serious for Equatorial Guinea, and surely for many other African states that face similar situations. France is acting in clear violation of the 2003 United Nations Convention Against Corruption, also known as the Merida Convention, the main multilateral instrument in the fight against the scourge of corruption. Its actions not only directly harm the sovereign rights and interests of my country, but they risk damaging the interstate cooperation within the framework of the Convention. By its actions, France threatens to render a central part of the Convention unworkable. Its own domestic law and authorities seem to ignore international law. They reflect the same unacceptable approach that has characterized France's action since the outset of the dispute. An approach which may be described as paternalistic and even neo-colonial. We cannot accept such disdain for our sovereignty from France. Mr. President, we cannot accept it. Mr. President, members of the court, the case that began in 2022 concerns the return of assets confiscated in criminal proceedings and the cooperation that is required from states in that regard pursuant to the Merida Convention. The French courts confiscated, among other assets, the building at 42 Avenue Foch, the subject of the present request for provisional measures, after finding that it was acquired with public funds embezzled from Equatorial Guinea. In these circumstances, the Convention, and in particular Article 57, requires that France return the asset in question to Equatorial Guinea. France must facilitate and cooperate with Equatorial Guinea to this effect, and in all circumstances act, we stress, in full respect of the fundamental principles of sovereign equality and non-intervention in the internal affairs of other states, as mandated by Article 4 of the Convention. It is now apparent that France refuses even to fulfill its obligations to cooperate in the implementation of the Merida Convention. France is creating fait accompli, leading inexorably to the sale of the building. This would effectively rule out the return of the building to Equatorial Guinea, in accordance with the Convention. Indeed, it has now become clear that France is determined to sell the building and to unilaterally decide the use to be given to the proceeds of the sale. France intends to decide the use of those funds in accordance with whatever development policies it wishes to pursue as a matter of its own sovereign choice and through private non-governmental organizations. In other words, France is arrogating to itself the power to determine how the public funds of Equatorial Guinea must be used without the consent of Equatorial Guinea. This is what the French law of programmation of 2021 allows and even mandates, and which manifestly contradicts the Merida Convention. No state other than Equatorial Guinea can determine how its own funds may be used. France's approach is and was and continues to be rejected by the negotiating states of the Merida Convention, as was reaffirmed by a recent UN General Assembly resolution to which my colleagues will draw attention. Nevertheless, I would like to inform you that France continues to engage in similar practices, as with the use of the reserve funds of 14 African countries held by the French Treasury. I recall, Mr. President, that Equatorial Guinea acquired the building at 42 Avenue Foch with the purpose of relocating the premises of its diplomatic mission in France. This is the use that Equatorial Guinea determined for that building. in accordance with its foreign policy needs. Equatorial Guinea, of course, did not question the court's judgment of 2020, where by 9 votes to 7, the court found that the building did not enjoy the status of premises of a diplomatic mission under the Vienna Convention on Diplomatic Relations. Contrary to France's assertions, the present proceedings in no way seek to challenge your judgment, which is final and binding for us. But the court did not say that the building could not continue to be used for representational or other important functions of a governmental nature. Mr. President, members of the court, the present request for provisional measures has become urgent because of certain unilateral steps that France took in recent weeks, steps that point towards the imminent sale of the building, a sale which could take place at any time before the court delivers its final judgment in this case. Early in the morning of the 18th of June, an agency of the French government, Agrasc, invaded the building unannounced and without warning, and proceeded, despite protests on our part, to exclude us from large parts of the building. There were more than 15 people. I myself was there. Agents of the French judicial police, members of private security companies, locksmiths, as well as police dogs stationed at the building. They changed the locks and effectively excluded us from large parts of the building. They deliberately destroyed internal surveillance cameras on several floors, thereby eliminating our ability to monitor the building and seriously compromising the security of governmental facilities, archives, and staff. This all happened without prior notice, without the consent of the state that occupied the building, without our presence, and without any respect for the forms that govern relations between sovereign states. I want to recall, Mr. President, that when we arrived at our premises at 42 Avenue Foch, the Agrasc, security agents, police dogs and locksmiths were already inside the building. To do this in our building, acquired with our own financial resources, and not just financial resources. This means that France has not yet understood that we Africans no longer accept interference in our internal affairs. Enough already with France seeking to administer Africa's resources without any respect. Enough with the manipulation of Africa's interests without permission. Enough with France unduly taking what does not belong to it to use it for its own benefit. We make this clear. We utilize our financial resources for what we consider is best for our country and not to benefit French interests. In Equatorial Guinea's view, the property is owned by the Equatorial Guinean state and is used for governmental, not commercial purposes. It therefore enjoys immunity. The fact that the French courts do not recognize this does not alter this position. The fact that this court did not have jurisdiction over this matter does not affect the situation either. In fact, I would like to inform you, Mr. President, members of the court, that France comes to our offices in this building to request official visas for its authorities or diplomats traveling to Equatorial Guinea. Mr. President, I would like to ask a question and offer some reflections. Does France sign international instruments only to then disregard them and impose its own domestic laws? Is France unable to respect a matter that is in the hands of this International Court of Justice? Why is France taking justice into its own hands instead of waiting for the final decision of this court? Yesterday, at the last minute, France sent us a lot of information that I do not understand the purpose of. Photos of broken locks, open offices, even the violation of the privacy of the identity cards of people who work or live in the building, including my own card. Mr. President, members of the court, all of this is completely irrelevant to this case in this court. In these circumstances, the indication of provisional measures has become urgent. Such measures are now essential if the court is to be in a position to decide this case and to deliver justice. As we have explained in our request for provisional measures, and as the members of our legal team will now show, all the requirements for the indication of provisional measures are met in the present case. Mr. President, members of the court, the following members of our delegation will address you in turn. First, Maître Jean-Charles Chikaya will speak about the French Loi de Programmation and its application, especially what the French authorities have been doing over the last few weeks. Second, Mr. Francisco Moro Nveo Bono will show that the first of the conditions for the indication of provisional measures is met, that the court is undoubtedly has prima facie jurisdiction in this case. Third, Dr. Alfredo Grossato Neumann will show that the rights claimed by Equatorial Guinea are plausible. Fourth, Sir Michael Wood will explain that there is urgency and that acts capable of causing irreparable damage may occur at any moment before the court gives its final decision in the case. Again, France's refusal to provide any assurances to the contrary is very telling in this regard. Sir Michael Wood will also explain the link between the rights whose protection is sought and the provisional measures requested, including a summary of the position of Equatorial Guinea. To conclude our presentation, I myself, as agent for the Republic of Equatorial Guinea, will offer some final remarks and read out our submissions to the court. Mr. President, members of the court, I thank you for your kind attention and request that you invite Maître Chikaya to the podium. Thank you very much.
I thank the agent of Equatorial Guinea for his statement. I now invite Mr. Jean-Charles Chikaya to address the court. Vous avez la parole.
You have the floor. Thank you, President. Mr. President, members of the court, it is a great honour for me to appear before the court on behalf of the Republic of Equatorial Guinea. As announced by the agent of Equatorial Guinea, I will first set out the factual background that led to the filing of this request for indication of provisional measures, giving a brief overview of French legislation on the return of confiscated property. Secondly, I will show that, despite the proceedings pending before the court, France has taken practical measures as evidenced by its decision to sell the property located at 42 Avenue Foch in Paris, which risk rendering the final judgment ineffective. Now, first of all, I would like to recall that in its application instituting proceedings, Equatorial Guinea respectfully requested the court to adjudge and declare that by refusing to return to it the building at 42 Avenue Foch, together with the other confiscated property, and by failing to grant Equatorial Guinea the cooperation and assistance provided for in the United Nations Convention Against Corruption, known as the Merida Convention, France has violated and continues to violate its obligations under that instrument. Turning now to France's clear intention to sell the property at 42 Avenue Foch. While Equatorial Guinea is preparing to submit its reply on the 28th of July, France, which is due to file its rejoinder on the 28th of May 2026, is pursuing a series of actions intended to cause irreparable prejudice to Equatorial Guinea. The latter has repeatedly asked France for assurances that it will refrain from aggravating the dispute, pending the court's decision on the merits, but in vain. Indeed, the developments of the 18th of June 2025, as recounted by the agent of Equatorial Guinea, and to which I will return in a moment, are merely the culmination of a deliberate and progressive process by France to irreparably prejudice the rights for which Equatorial Guinea is requesting protection. Now, before going into more detail about this process, it's important to recall that the criminal proceedings initiated in France between 2007 and 2021 concerned the acquisition on French territory of property that the French courts deemed to be the proceeds of the laundering of misappropriated public funds to the prejudice of the Equatorial Guinean Treasury. It was in the context of these criminal proceedings that the building at 42 Avenue Foch was confiscated, along with other movable property. Now, for its part, and drawing the consequences of a judgment handed down by the French Court of Cassation on the 28th of July 2021, which definitively held that Equatorial Guinean public funds had permitted the acquisition in France of the confiscated property, Equatorial Guinea, as the requesting victim state, requested France in September 2021 to return the property in question, in particular the building at 42 Avenue Foch, invoking the Mérida Convention. Now, while it is true that according to paragraph 2 of Article 57 of the Mérida Convention, and I quote, each state party shall adopt such legislative and other measures in accordance with the fundamental principles of its domestic law as may be necessary to enable its competent authorities to return confiscated property when acting on the request made by another state party in accordance with this convention, taking into account the rights of bona fide third parties. End of quotation. Now, despite this, France has nonetheless adopted a law, the purpose of which is not to return property confiscated from other state parties. In its letter to his Equatorial Guinean counterpart, dated the 22nd of June 2022, which is Annex 23 to Equatorial Guinea's memorial, the French president announced the forthcoming enactment of this law, as well as the need to sell the property at 42 Avenue Foch. Indeed, immediately after the aforementioned judgment was handed down, France opportunely adopted a law known as the Law of the 4th of August 2021 on solidarity-based development and the fight against global inequalities. And it is available in tab 2 of your file. Now, this law, which purports to combat global inequalities, nevertheless provides as follows, and I quote, proceeds from the sale of confiscated property shall give rise to the allocation of budgetary appropriations in the Official Development Assistance Programme, under the responsibility of the Ministry of Foreign Affairs, and shall finance cooperation and development actions in the countries concerned as close as possible to the people, in accordance with the principles of transparency and accountability, and ensuring the involvement of civil society organisations. The Ministry of Foreign Affairs shall determine on a case-by-case basis the terms and conditions for returning these proceeds, in order to ensure that they contribute to improving the living conditions of the populations concerned. So, in short, the French law of the 4th of August 2021 gives the French Ministry for Europe and Foreign Affairs the discretionary power to allocate the proceeds from the sale of confiscated property in accordance with France's development policy. In other words, France confiscates property that has been misappropriated to the prejudice of another foreign state, sells it on its territory at sometimes derisory prices, reclassifies it as national budgetary funds, and then unilaterally repackages it as official development assistance, supposedly for the benefit of the people of the plundered country of origin. In fact, under the guise of cooperation, this mechanism allows France to finance its own foreign policy while interfering in the internal affairs of third countries that are victims of misappropriation of funds. A circular issued by the Ministry of Justice on the 22nd of November 2022 further clarifies the procedure for applying this law. And you will find this circular in your file under tab E. Now, this mechanism has been in place since 2022, as the proceeds from the sale of property confiscated in international corruption cases are included in a specific budgetary programme, known as Programme 370, which is managed by the Ministry of Foreign Affairs and through which the programming law is implemented. Now, no provision of this law requires the Ministry to return the proceeds to the requesting state that was the victim of the misappropriation of funds, or to cooperate with that state to secure the direct return of the confiscated property, contrary to France's obligations under the Mérida Convention. The provisions of that same law requires France to sell confiscated property and use the proceeds of the sale at its discretion, as closely as possible to the people, as the law says, the people of the dispossessed state, thereby violating the principles of the sovereign equality of states and of non-intervention in the internal affairs of other states, as recorded in Article 4 of the Convention. Now, the reality is that France confiscates property acquired on its territory through the misappropriation of public funds from third states, preferably African ones, and then, thanks to its most opportune domestic legislation, appropriates the same property or the proceeds of its sale, simply refusing to return it to the victim states, which thus find themselves twice dispossessed. Furthermore, France's position of making the return of property contingent on the requesting states recognizing that a crime has been or even could have been committed, such that it has concluded that because Equatorial Guinea has not admitted that offences were committed on its territory, Equatorial Guinea is not a requesting state. Now, this position of France is an overly restrictive and therefore erroneous interpretation of the Merida Convention. As Equatorial Guinea explains in detail in its memorial, this French legislation on the return of confiscated assets is clearly incompatible with the Convention. Now, this is also the opinion of the United Nations Office on Drugs and Crime, which, in a country report, points out that the French programming law, and I quote, clearly falls outside the framework prescribed by Article 52, Paragraph 3, for the return of confiscated assets, end of quotation, such that it recommended that France, and I quote, that France take the necessary steps to ensure that confiscated property is returned in accordance with Article 57 of the Convention, even in the absence of an agreement with the requesting state. End of quotation. Therefore, only by maintaining the status quo can your court ensure that the substance of the dispute remain pending until its peaceful and final settlement. Failing that, France will have succeeded through these unilateral acts in rendering the proceedings before this court devoid of any substance. Now, turning to the reality and the imminence of the sale of the building at 42 Avenue Foch, it should be recalled that on the 29th of July 2022, the Agency for the Management and Recovery of Seized and Confiscated Assets, AGRASC, which is a body under the joint supervision of the French Ministries of Justice and Public Accounts, notified the occupants of 42 Avenue Foch of its intention to dispose of the building. And this led Equatorial Guinea to submit to the court a first request for indication of provisional measures, attached to its application institution proceedings of the 29th of September 2022, a request which Equatorial Guinea withdrew on the 19th of October 2022 in a spirit of good procedural cooperation and trust towards France. However, on the 20th of January 2023, France did not hesitate to sell at public auction confiscated movable property that is the subject of the present case. In short, Equatorial Guinea is pointing out the incompatibility of French legislation on restitution with the Convention on the one hand, and France's sale of the other property in 2023 on the other, to demonstrate that France is now determined to sell the building at 42 Avenue Foch as well, and that the sales process is well underway. Mr. President, members of the court, I now turn to the recent events that have compelled Equatorial Guinea to submit this request for provisional measures to you. First of all, on the 27th of May 2025, AGRASC submitted a request to the President of the Tribunal Judiciaire in Paris to appoint a court enforcement officer, basically a bailiff. This is the new terminology in France, a court enforcement officer. And so appointment of such an individual, assisted by law enforcement and a locksmith, if necessary, with the task of entering the building at 42 Avenue Foch, with the task of, and I quote, drawing up a complete inventory, checking the conditions of occupancy of the premises, and identifying or seeking to identify all occupants, as well as the conditions of their entry to the premises. End of quotation. Then on the 3rd of June 2025, the President of the Tribunal Judiciaire issued an order granting Agrasc's request. Now, at this point, I would respectfully draw the Court's attention to Annex 5, produced by France, which is an Agrasc document, as we can all see, which is entitled Treatment of Sales of Confiscated Real Estate, updated version 2025. Now, this document specifies that among the steps prior to offering confiscated property for sale, after checks by the tax authorities, there is a second stage, which is the production of a report by a court enforcement officer. Now, this document sufficiently proves that France has not only taken the decision to sell the building, but is already in the second phase of the sale, which may be completed at any time. So the tax authority checks have taken place, and the court enforcement officer has already done his work. He has already produced his report on site, so presumably we are now in phase 3. How is it possible to claim that the sale is not imminent against this background? As Mr. Michael Wood will report soon, it is now a matter of urgency that provisional measures be ordered. Finally, on the 18th of June 2025, in execution of the said order by the President of the Tribunal in Paris, the designated court enforcement officer, Agrasc agents, national police officers, members of a private security company, locksmiths, and even police dogs took action at 42 Avenue Foch. The locks on the main and rear doors of the first, second, and third floors of the buildings were changed, the keys confiscated, the surveillance cameras destroyed, and access at the gate blocked. The following day, in a note verbale dated the 19th of June 2025, the French Ministry of Foreign Affairs in Europe stated that it had not been informed of this intervention, while confirming that the operations carried out by Agrasc were in enforcement of the judgment of the 28th of July 2021 delivered by the Court of Cassation, which confirmed the definitive confiscation of the building. Now, in view of this situation, Equatorial Guinea requested guarantees from France that it would refrain from any action that might aggravate the dispute or cause irreparable prejudice to Equatorial Guinea. To date, no response has been received from France as regards such assurances. Now, France's stubborn refusal to provide such assurances confirms its unwillingness to preserve the core substance of the present dispute and therefore justifies the court's indication of provisional measures. To illustrate anew France's determination to sell the building, I respectfully draw the court's attention to the explicit terms contained in Agrasc's application. In its application to the President of the Tribunal Judiciaire in France, Agrasc states that, and I quote, "The confiscated property has belonged to the French state since the 28th of July 2021, and that Agrasc must perform its legal duty to sell the property." End of quotation. Now, this statement, made in a court document, proves that the sale of the building is likely to take place at any time. Furthermore, the use of the verb must implies that France considers itself under an obligation to sell, bound to sell, as required by its domestic legislation on the matter. Therefore, France cannot deny before the court the reality of the imminent disposal of the property. Verba volant, scripta manent. Furthermore, it is relevant to note that, despite its lengthy application, Agrasc did not at any point mention the proceedings for restitution pending before this court. Such an omission is not accidental. It is part of a strategy of fait accompli. We do not know whether, if the President of the Tribunal Judiciaire had been aware of the proceedings for this court, whether he might not have rejected the application, because what he in fact wrote confirms what our view. Mr. President, allow me to quote the position of the French courts, which highlight the inconsistency of France's decision to sell the building that it refuses to return to Equatorial Guinea. In 2017, the Tribunal Correctionnel in Paris ruled the following. And this is the court that found that the entity was subject to criminal proceedings. The Tribunal Correctionnel ruled that, in fact, and I quote, in fact, in the traditional view, confiscation applies in particular to property that is not capable of being returned and results of the property being transferred to the French state. Given the nature of transnational corruption, it now appears morally unjustified for the state ordering the confiscation to benefit from it without regard for the consequences of the offence. The return of assets is a fundamental principle of the United Nations Convention Against Corruption, known as the Merida Convention, which is the first universal and comprehensive instrument to combat corruption. The return of assets is the subject of a section of the Convention, Article 51. The Convention is the first international instrument to detail the procedures for returning to states funds derived from corruption of which they have been deprived and which have been transferred abroad by political leaders or public officials. End of quotation from the ruling of the Paris Tribunal Correctionnel. So this ruling clearly illustrates that the confiscation of assets derived from corruption must not be accompanied by the unjust enrichment of the state whose courts have ordered the confiscation. Yet, this is precisely what France is doing today. It refuses to cooperate in any way to secure the return of the property, despite the rulings to the contrary of its own courts based on the Merida Convention. It should be noted that, to date, France has been unable to cite a single case of restitution under its programming law, restitution to any third country. Mr. President, members of the Court, in conclusion, my presentation of the factual background to this request for indication of provisional measures can be summarised in 4 points. Firstly, France, under the guise of criminal proceedings, having definitively considered that the building at 42 Avenue Foch was acquired using funds from the Equatorial Guinean public treasury, refuses to return it to Equatorial Guinea and has decided to sell it. And that in violation of the Merida Convention and despite the proceedings currently pending before this court. Secondly, barely a week after the Court of Cassation's judgment of the 28th of July 2021 confiscating the building, France opportunely adopted a law on the return of confiscated property, which requires it to sell the property and gives it discretionary power to allocate the proceeds in line with its own foreign policy, even without the consent of or regard to the views of the victim state. Thirdly, on the 18th of June 2025, pursuant to a court order, Agrasc took enforcement measures aimed at the imminent sale of the building at 42 Avenue Foch, as required by French law on the matter, while stating to the president of the Tribunal Judiciaire in Paris that it intended, and I quote, to be able to bring an action for eviction or to have a direct order to vacate the premises issued pursuant to the new provisions of Article 131-21, paragraph 15 of the Criminal Code. End of quotation. Those provisions state, and I quote, that the final decision to confiscate immovable property constitutes a title of eviction against the convicted person and or any occupant. End of quotation. Finally, fourthly, the reality of the imminent sale of the building, which is evidenced by the sole decision referred to above taken by France, France which claims to be the owner of the building, should not be confused with the actual transfer of ownership, which in the case of a building requires the signing of a preliminary sales agreement before a notary. So the sale has already been decided. The sale has been executed, is being executed, and we are in the third phase of that sale. It follows that, unless France, perhaps this afternoon, agrees to provide Equatorial Guinea with assurances that it does not intend to sell to sell the building in question until this court has delivered its judgment on the merits of this case. Only the indication of provisional measures will suffice to preserve the rights in dispute by maintaining the status quo, to preserve those rights until this court rules on the merits of the case. Mr. President, members of the court, this brings to an end my presentation on behalf of Equatorial Guinea. I warmly thank the court for its kind attention, and I respectfully request, Mr. President, that you call to the bar Mr. Francisco Moro Nve Obono, who will show that the court has prima facie jurisdiction at this stage of the proceedings.
I thank Mr. Chikaya for his statement. I now call Mr. Francisco Moro Nve Obono to the podium. Sir.
Mr. President, members of the court, it is an honor for me to appear before you on behalf of my country, the Republic of Equatorial Guinea. Mr. President, the conditions for the indication of provisional measures are well established in the court's case law. The first of these concerns the court's prima facie jurisdiction. As the court has had several occasions to reiterate, including recently, at this stage of the proceedings, it need not satisfy itself in a definitive manner that it has jurisdiction as regards the merits of the case. Indeed, the court need only find that the provisions relied on by the applicant appear prima facie to afford a basis on which its jurisdiction could be founded. As I shall demonstrate this morning, this is a case where jurisdiction is clear, certainly prima facie. Equatorial Guinea seeks to found this jurisdiction on Article 36, Paragraph 1 of the Statute of the Court and on Article 66 of the United Nations Convention Against Corruption. This convention, the Merida Convention, is in force between the parties, neither of whom has made any reservation. Article 66 of the Convention is at tab PQ in the judges' folders. Paragraph 2 of the provision provides that any dispute between two or more states parties concerning the interpretation or application of this convention that cannot be settled through negotiation within a reasonable time shall, at the request of one of those states parties, be submitted to arbitration. If 6 months after the date of the request for arbitration, those states parties are unable to agree on the organization of the arbitration, any one of those states parties may refer the dispute to the International Court of Justice by request in accordance with the statute of the court. This Article 66, Paragraph 2, is similar to a number of dispute settlement clauses to be found in multilateral conventions, clauses which have frequently been considered by the court and on which your case law sheds much light. The paragraph sets out 5 conditions. First, that there is a dispute concerning the interpretation or application of the convention. Second, that the dispute cannot be settled through negotiation within a reasonable time. Third, that there is a request for arbitration submitted by one of the parties. Fourth, that the organization of the arbitration has not been agreed within 6 months of that request. Fifth, and last condition, that one of the parties refers the dispute to the court by request in accordance with the statute. As we explained in the application instituting proceedings, in the memorial, and also in the request for provisional measures, these conditions are met and the court has jurisdiction. As the court is aware, France did not raise preliminary objections to jurisdiction within the time limit fixed by Article 79 bis of the Rules of Court. Its counter-memorial, filed in February of last year, does not contain any chapter dealing exclusively with jurisdiction. Instead, in a rather long chapter entitled "The Claims of Equatorial Guinea Must Be Rejected," France argues that several reasons, based both on the competence of the court and on the merits, which are closely related, justify such rejection. The statement, which suggests that according to France the merits of this case have a bearing on the court's jurisdiction, may itself be regarded an acceptance of prima facie jurisdiction. One is indeed left in the dark as to which of France's arguments in the counter-memorial relate to jurisdiction, and which to the merits or possibly to admissibility. Mr. President, in order to determine whether the disputes between the parties concerns the interpretation or application of the Merida Convention, the court must ascertain whether the acts complained of by the applicant, my country, are prima facie capable of falling within the provisions of that instrument, and whether, as a consequence, the dispute is one which the court could have jurisdiction, ratione materiae, to entertain. It is not entirely clear from the ambiguous language of the counter-memorial whether France contests that there is a dispute between the parties concerning the interpretation or application of the Convention. I shall return to what it says on this later. For now, it is sufficient to say that the acts complained of by Equatorial Guinea are France's violation of its obligation, under central provisions of the Merida Convention, to return to the sovereign people of Equatorial Guinea assets belonging to it, and of its obligation to cooperate with it to achieve this purpose, in application of the Convention, and in a manner consistent with the principles of sovereign equality and non-intervention in the internal affairs of other states. Key provisions of the Convention, including Articles 4, 51, and 57, are at issue. There can be no doubt that a dispute exists between the parties concerning the interpretation and application of the Convention. Indeed, France admits as much in its counter-memorial when it says that Equatorial Guinea would have added a certain element of complexity to the already ongoing discussions and analysis regarding the interpretation and application of the Merida Convention. Before submitting the dispute to the court, Your Excellencies, if France is willing to say this afternoon that it accepts that Equatorial Guinea is, and the sovereign people of Equatorial Guinea as a victim is entitled under the Convention to the unconditional return of the building and to cooperation from France in this regard, we would of course be pleased to hear that. France does not, in the counter-memorial, seek to argue that there was no request for the submission of the dispute to arbitration. Clearly, there was, Your Excellencies. I draw your attention to Equatorial's letter of the 6th of January 2022, which is at tab R of your folders. Nor does France argue that 6 months after the date of the request for arbitration, that is to say, on the 6th of July 2022, France and Equatorial Guinea were unable to agree on the organization of the arbitration. France could not so argue, since it had failed to respond in any way to Equatorial Guinea's request for arbitration. That failure even to reply is typical of its dismissive attitude to the applicant. With a view to assisting the court, I shall now seek to engage in what is necessarily a somewhat speculative analysis of arguments scattered throughout France's counter-memorial, some of which may be intended to address the court's jurisdiction, while others may not. We may, or may not, have more clarity this afternoon. But, given the procedural arrangements for this hearing, Equatorial Guinea will presumably not have an opportunity to comment further on France's case on prima facie jurisdiction. The following 3 points in France's counter-memorial may be intended to support, in their view, the submission that the court has no jurisdiction. Firstly, that the negotiation precondition in Article 66 of the Merida Convention was not met. Secondly, that the requirement for reasonable time was not respected. Thirdly, and finally, that there is no dispute. In fact, the first 2 points are really a single point, which I shall address first. The third, as I shall explain, on closer examination seems not to relate to jurisdiction, but to the merits. Article 66, paragraph 2 of the Merida Convention sets out a precondition for requesting arbitration, that a dispute cannot be settled through negotiation within a reasonable time. Excellencies, it is noteworthy that when Equatorial Guinea requested arbitration on the 6th of January 2022, and recalled this once again on the 14th of June of that year, France made no reference to this precondition, but only did so more than 2 years later in its counter-memorial. I note that on the 6th of January 2022, or that rather, that the 6th of January 2022 is the critical date for the negotiations precondition. Later correspondence, such as that referred to by France in this regard, is simply not relevant for the present purposes. In the counter-memorial, France gives a brief and partial account of the court's case law on negotiation preconditions, with heavy reliance on a case decided over 60 years ago, the Southwest Africa case. It considers very briefly a couple of communications made by or on behalf of Equatorial Guinea to France. It completely omits to mention France's response, or rather, lack of response. But this lack of response is of great significance. It takes two to negotiate. France omits to mention that it was entirely because of its own unwillingness to negotiate, except on its own terms, that is, within the framework of its own legislation and after the sale of the building. That negotiation would take place after the sale of the building. In the counter-memorial, it refers quite insultingly and very tellingly to a need to adopt innovative mechanisms. Since, so it says, with disdain, that it would be difficult to conclude an agreement with a state like Equatorial Guinea. Your Excellencies, by the time Equatorial Guinea requested arbitration, the prospect of negotiations over the Merida Convention dispute succeeding was zero. In its counter-memorial, France itself cites some of the relevant case law. It could also have mentioned the Lockerbie cases. In the present case, there undoubtedly was a true impasse. The two sides were at cross purposes. As we have seen, while Equatorial Guinea sought to negotiate the difference over the Merida Convention, all France was prepared to talk about, at some future point, was the application of its own legislation, running counter to the spirit of the Merida Convention. I recall, Mr. President, that Equatorial Guinea sent a request seeking expressly the return of the building on the 14th of September 2021. This was accompanied by a detailed memorandum prepared by the Deputy Minister of Justice at the time, which concerned the Merida Convention specifically. The memorandum was again sent to France on the 27th of October 2021. On the 3rd of December 2021, a bilateral meeting in the French presidential palace took place, but proved futile. These communications are at tab S of your folders. Contrary to what France suggests, all these communications were also crystal clear about the subject matter of the dispute. France's obligations to return assets to Equatorial Guinea and its sovereign people, and to cooperate with it under the Merida Convention. And they were crystal clear that further prolonging the delay would have led to no progress, would have led to no solution for the parties. France makes various points in its counter-memorial, but those are simply not relevant to the Merida dispute. The fact is that France was not prepared to negotiate over the Merida Convention, but only about the implementation of its own national law. It did not seem that France was interested in its obligations under the Merida Convention, but only about the implementation of its own law, which, as we have explained in the memorial, is inconsistent with the Convention and with the spirit of the Convention. After all, France says clearly in its counter-memorial that Article 57 of the Merida Convention is not applicable in the circumstances, and that the people of Equatorial Guinea has no right under it to the return of its property, of its sovereign property. The following arguments in the counter-memorial do not go to jurisdiction, but to the merits of the case, or possibly to admissibility. Again, I mention them only because we do not know what France will raise this afternoon. In the introduction to its counter-memorial, France asserts that Equatorial Guinea is somehow perverting the object and purpose of the Merida Convention. It refers to un usage dévoyé and a dévoiement. These are hardly legal terms, but any legal argument that may be implied would go to the merits, which we shall be dealing with in our reply due on the 28th of July. France has not yet invoked abuse of rights or abuse of process, though on past form it cannot be excluded that they will seek to do so this afternoon. Such invocation would be baseless in fact and law. Suffice to recall your case law, including your 2018 judgment on preliminary objections in the previous case between Equatorial Guinea and France. Just as in that case, an allegation of abuse of rights is a matter for the merits. If France were to raise an abuse of process argument today, not only would it be out of time, if only for reasons of procedural fairness, but it would be necessary to recall that such invocation could not succeed without clear evidence that Equatorial Guinea's conduct could amount to an abuse of process, and which would require exceptional circumstances. As in 2018, the present case where Equatorial Guinea seeks to exercise its rights under international law by way of a peaceful settlement mechanism does not present such circumstances. In the second part of the introduction, France accuses Equatorial Guinea of wrongfully seeking recourse to the International Court of Justice as a court of appeal against the decisions of the French courts, or even refusing to accept the binding decisions of the present court. That second point is false, with all due respect. We have never sought to reopen the court's binding decisions. In any event, these are arguments for the merits. As regards the first point, it is clearly out of place, because the responsibility of a state may well be engaged for acts carried out by its national courts as organs of the state, if those acts are contrary to international law. This does not make this court a court of appeal, as France puts it. Moreover, Equatorial Guinea is not now challenging the past decisions of French courts. Quite the opposite. Equatorial Guinea's claim for return of assets is based precisely on the determinations by French courts concerning the commission of certain crimes in Equatorial Guinea and in France. This, again, is something for the merits. Also in the introduction, France suggests that Equatorial Guinea's critique of the French legislation is abstract and not for the court. This, again, goes to the merits. In arguing that Equatorial Guinea's application is manifestly ill-founded, France accepts that this is a matter for the merits. Indeed, the article in question begins with the words "if." The court finds itself to have jurisdiction. This conclusion is not affected by France's remarkable suggestion that the court should reject Equatorial Guinea's claims in limine litis, something the court has only done on very rare occasions, where there was clearly no jurisdiction. In any event, France's argument at this point goes to the heart of the merits of the case, and turns on the interpretation and application of Article 57 and other provisions of the Merida Convention. There is a lengthy section of the counter-memorial entitled "The Failings of Equatorial Guinea's Application as regards the object of the alleged dispute." In it, France engages in a detailed analysis of the various provisions of the Merida Convention, even invoking a footnote in the preparatory work, and looks at a range of documents before concluding that the claims of Equatorial Guinea is without object. This too is self-evidently about the merits. Even if these were arguments about jurisdiction, they obviously would not show the absence of prima facie jurisdiction of the court. To conclude, Mr. President, members of the court, I think I have said enough to show that there can be no doubt that Article 66 of the Merida Convention appears, prima facie, to afford a basis on which the court's jurisdiction could be founded. Indeed, we could go further and say that this is a case where jurisdiction is clear. Mr. President, Excellencies, this concludes my statement. I request that you invite Mr. Crossato to the podium. Thank you very much.
Mr. President, members of the court, it is a great honor for me to appear before you on behalf of the Republic of Equatorial Guinea. I will now address the issue of the plausibility of rights claimed by Equatorial Guinea on the basis of the Merida Convention. It is well established in your jurisprudence that at this stage of the proceedings, the court is not called upon to determine definitely whether the rights which the applicant wishes to see protected exist. It has to be determined whether at least these rights are plausible. That condition, as I shall demonstrate, has been met in the present case. The right that Equatorial Guinea is primarily seeking to protect through the request for provisional measures is that of the return of the property located at 42 Avenue Foch in Paris. This building, as Mr. Shikaya recalled, was confiscated during criminal proceedings conducted in France. According to the French courts, the building is the proceeds of the offence of misappropriation of public funds committed in Equatorial Guinea, as well as the offence of laundering those funds in France. Both offences are covered by Articles 17 and 23 of the Convention. In this context, the right to return that Guinea claims is provided for in Chapter 5 of the Convention, entitled Asset Recovery, and notably Article 57, Paragraph 3, Subparagraph C. The first paragraph reads, and I quote, "Property confiscated by a state party pursuant to Article 31 or 55 of this Convention shall be disposed of, including by return to its prior legitimate owners, pursuant to paragraph 3 of this article by that state party in accordance with the provisions of this Convention and its domestic law." The first paragraph therefore requires the requested state in all cases to dispose of the confiscated assets in accordance with the Convention. No exception is envisaged. Paragraph 3 sets out the modalities for the fulfillment of this obligation. Subparagraphs A and B refer to embezzlement of public funds and other offences covered by the Convention when confiscation was executed in accordance with Article 55 and on the basis of a final judgment in the requesting state party. Subparagraph C stipulates that the requested state in all other cases shall give priority consideration to returning confiscated property to the requesting state party, returning such property to its prior legitimate owners, or compensating the victims of the crime. It is this provision that applies in the present case. The French authorities have themselves conducted the criminal proceedings in question and established that the offences of misappropriation of public funds and money laundering had been committed. Equatorial Guinea's request to return the assets was made at the end of these criminal proceedings. In addition to the return of the building, Equatorial Guinea also asserts its right to cooperation for the purposes of return, as provided for in Article 51 of the Convention, as well as to the respect of the principles of sovereign equality and non-intervention in the internal affairs of other states. The rights that I just mentioned are a key aspect of the Convention. They were the subject of lengthy debates when the treaty was negotiated, during which conflicting positions existed between developing countries and developed countries. At the heart of these debates is the question of whether these assets that were confiscated, particularly when they are the proceeds of embezzlement of public funds, should be returned to the state that is at the origin of these funds, or whether, on the contrary, the requested state could impose conditions on their return, or even be the one to decide, instead of the requesting state, what should happen to this confiscated property. The position of the developing countries in this regard has always been unequivocal. The requested state is obliged to cooperate and return the property without imposing any conditions and in full respect of the principles of sovereign equality and of non-intervention. The Convention finally retained this position and this was a major breakthrough in international law in the fight against corruption. In the present case, the position of the parties is radically opposed. France holds that it is not required to return the property to Equatorial Guinea. It intends first to sell the property and then look for an agreement with Equatorial Guinea based on French policy in the field of development. However, as the agent recalled, it appears that France already considers that it would not be possible to reach an agreement with Equatorial Guinea in this respect. In any case, at this stage, the programming law allows the French Ministry of Foreign Affairs to determine unilaterally how the funds will be used. The funds would eventually be allocated to non-governmental organizations selected by France. These NGOs would conduct different projects in Equatorial Guinea in favor of the affected populations. And all this will be done, Mr. President, members of the court, without Equatorial Guinea's consent. That, in a nutshell, is the unrealistic modality of return envisaged by France in the present case. It unilaterally claims, therefore, the power to decide how public funds of the Treasury of Equatorial Guinea should be used, or to impose conditions on Equatorial Guinea concerning their utilization. This position has no basis in the Convention. The text of Article 57 is perfectly clear. As I indicated, the requested state must dispose of this confiscated property, and it must do so in accordance with paragraph 3. This is self-evident, in particular when it concerns the embezzlement of public funds belonging to the requesting state. Public funds of a state treasury constitute financial resources over which the states have exclusive sovereignty. It would therefore be absurd to say that the requested state could keep them or impose conditions on how they should be used. Article 57, paragraph 3, subparagraph C, provides for three possibilities that should be considered on a case-by-case basis. It should be emphasized that the Convention provides for no other modality for the utilization of confiscated assets. It certainly doesn't mention the innovative mechanisms that France claims to be imposing on Equatorial Guinea. As France argued in its counter-memorial that the obligation to consider as a matter of priority does not necessarily require the return of the confiscated property, and that it is merely a guideline. France also suggested that the Convention confers a broad discretionary power on it. And as we have explained, this argument is not compatible with the text of Article 57 read as a whole. Paragraph 3 expressly refers to paragraph 1 and therefore refers to the obligation to dispose of confiscated goods and property in accordance with the Convention. Paragraph 1 mentions the return of property to prior legitimate owners, modality of return that is provided for in subparagraph C of paragraph 3. Therefore, France indeed has the obligation to return the building to Equatorial Guinea without exception, while giving priority to the modalities agreed upon by the states parties to the Convention. This interpretation is also based on the object and purpose of the Convention. Article 1, in accordance with the preamble, recalls that one of the objects is to promote, facilitate and support international cooperation and technical assistance in the prevention and fight against corruption, including in asset recovery. Article 51 is also central in this context. It concerns a general provision that informs Chapter 5 of the Convention as a whole. It provides that the return of assets is a fundamental principle of this Convention, and state parties shall afford one another the widest measure of cooperation and assistance in this regard. In view of the provisions that I have just recalled, the UN Office on Drugs and Crimes has explained in its legislative guide that Article 57 establishes a general presumption in accordance with the fundamental principle of Article 51 of repatriation of confiscated proceeds to the requesting state party, in particular when the claim of pre-existing property ownership is very strong, such as in cases of embezzled public funds. The guide also notes that Article 57 leaves very little discretion to state parties about this article, that state parties are required to implement these provisions. It's paragraph 3 retains the preference for the return to requesting state parties. Therefore, in this case, there is no doubt that Equatorial Guinea is a requesting party. It is the only state requesting the return of the building, and it is a product of investment of public funds in Equatorial Guinea. Any attempt by France to deny Equatorial Guinea this status is doomed to failure. Furthermore, Equatorial Guinea is clearly the prior legitimate owner of the public funds that were allegedly embezzled from the Treasury. Equatorial Guinea can also be considered as the victim of the offense of the misappropriation of public funds, given that it causes prejudice to the state of origin of the funds. The request for return, therefore, falls within all the cases set out in subparagraph C of paragraph 3 of Article 57. It should also be emphasized that the Convention defines the term property in general terms. According to Article 2, it includes assets of every kind, whether corporeal or incorporeal, movable or immovable, tangible or intangible, and legal documents or instruments evidencing title to or interest in such assets. An interpretive note of the Convention clarifies that the return of confiscated property may in some cases mean return of title or value. In the present case, as the agent explained, Equatorial Guinea is seeking the return of the immeuble at 42 Avenue Foch as such in the context of its long-standing use for the purposes of Equatorial Guinea's foreign policy. It is not requesting the return of the proceeds of the sale of the building to Equatorial Guinea's treasury. Mr. President, France could, as it did in its counter-memorial, invoke paragraph 5 of Article 57 this afternoon. However, this provision is not decisive in this case. Even if it were applicable, France could not act without the consent of Equatorial Guinea. The parties must cooperate and negotiate on the return and find a mutually acceptable solution. However, this solution seems impossible in light of the programming law that allows France to dispose of the building and even the proceeds of its sale in a unilateral manner. Finally, Mr. President, we must recall Article 4, Paragraph 1 of the Convention that provides that state parties shall carry out their obligations under this convention in a manner consistent with the principles of sovereign equality and territorial integrity of states and that of non-intervention in the domestic affairs of other states. You're already familiar with a similar provision drafted in identical terms in the Immunities and Criminal Proceedings case, Article 4 of the UN Convention Against Transnational Organized Crime. According to your 2018 judgment, this provision imposes an obligation on states parties. Its purpose is to ensure that state parties to the Convention perform their obligations in accordance with the principles mentioned therein. State parties, therefore, must respect these principles included in this Convention through Article 4 when interpreting and applying the obligations concerning the recovery of assets provided for in Chapter 5 of the Convention. The Conference of State Parties to the Convention, the Merida Convention, and the UN General Assembly have also affirmed this obligation in the clearest terms. There can be no question, Mr. President, that the states have sovereign and exclusive right to determine the use of property that belongs to them, and also as to the use of public funds. The choice of states are their prerogative, and there should be no discussion on this. Indeed, a large number of states, including African countries, the Arab world, China, have held that the return of assets to the requesting state cannot be subjected to conditions that would undermine its sovereignty. In short, France must return the building at 42 Avenue Foch to Equatorial Guinea without imposing conditions or deciding on its behalf how these funds should be used. What France claims to be doing in accordance with its domestic law would constitute a very serious intervention in an area where Equatorial Guinea, just like any other state, enjoys freedom of action. Before I conclude, Mr. President, allow me to recall Resolution 79/234 of the UN General Assembly, adopted without vote very recently in December 2024. This resolution, amongst other things, notes with concern that proceeds derived from offences established under the Merida Convention have yet to be disposed of in favour of the requesting state parties, their prior legitimate owners, and victims of the crimes. It also invites states to cooperate to recover the proceeds of crime as defined in the Convention and to fulfill their obligation to ensure the return and disposal of such proceeds in accordance with Article 57 of the Convention. In this context, the General Assembly reiterated the importance of Chapter 5 of the Convention and called for its full and effective application while recovering that recovery and return of property is a fundamental principle of the Convention. Equatorial Guinea, like other developing countries, shares this view. These issues are of great importance, which, despite progress made at the international level, unfortunately continue to pose problems. It will be up to your court to clarify these questions on the merits. At this stage, as I have recalled, it is sufficient for the court to determine that the rights claimed by Equatorial Guinea in the present case are at least plausible, and it is clear, as I have just demonstrated, that Equatorial Guinea has a plausible right to the return of the building at 42 Avenue Foch. It has a right to cooperation from France in relation to this return, and the right to France's respect in this context for the fundamental principles of sovereign equality and non-intervention in the internal affairs of other states. The condition of plausibility of rights for the indication of provisional measures is therefore satisfied. Mr. President, members of the Court, this concludes my oral statement. I thank you for your attention and respectfully request you, Mr. President, to give the floor to Sir Michael Wood. Thank you very much.
I thank Mr. Grossard-Newman for his statement. I now call on Sir Michael Wood to the podium. Sir.
Thank you very much, Mr. President. Mr. President, members of the Court. I take it that if we need it, we have until about 12 in light of what you said during the introduction. It's a great honour to appear before you on behalf of the Republic of Equatorial Guinea. As you know, Equatorial Guinea's objective in making the present request is to ensure that the building at 42 Avenue Foch is not sold pending a final decision of this court, and thus to avoid irreparable prejudice being caused to Equatorial Guinea's rights under the Merida Convention to the return of the property and to France's cooperation to that end. My statement will be in two parts. In the first part, I shall explain that, without the requested provisional measures, there is a risk of irreparable prejudice to Equatorial Guinea's rights, and that the situation is urgent within the meaning of the Court's jurisprudence. In the second part, I shall address the link between the rights whose protection is being sought and the provisional measures requested. Mr. President, the Court's case law is clear on the condition of risk of irreparable prejudice. This is prejudice that may not be capable of remedy since, and I quote, "it might not be possible to restore the situation to the status quo ante, or to preserve or restore the rights at issue." In the present case, France's actions are leading inexorably to a situation in which the rights of Equatorial Guinea will be irreparably harmed before this court has rendered a final judgment. The sale of the building at 42 Avenue Foch would cause irreparable prejudice in two ways. First, it would make it impossible to give effect to Equatorial Guinea's right under the Merida Convention to the return of the building. Second, it would render illusory Equatorial Guinea's right under the Convention to cooperation from France to this end. Mr. President, the Merida Convention is unique in requiring the return of property as a central element of the legal regime that it establishes. This, as well as the important symbolic nature of the building, distinguishes the present case from other cases where the sale of property might be made good through monetary compensation. Mr. President, the core of the dispute in the present case is the obligation to return assets and to cooperate in this regard. Equatorial Guinea's principal claim before the court is that France, pursuant to Article 57 of the Merida Convention, must return the confiscated property to Equatorial Guinea. In the circumstance of this case, this right does not relate to the return of the proceeds of any sale, but to the return of the assets themselves, chief among them the building at 42 Avenue Foch. Since Equatorial Guinea has at least a plausible right under the Merida Convention to the return of the building, that right must be protected pending your decision. The sale of the building to a third party would make its return materially and legally impossible, and Equatorial Guinea's right to recover this specific asset would be definitively lost. As the Court has recognised in other cases, the loss of certain rights cannot be adequately remedied by monetary compensation. That this may extend to rights to assets was confirmed by this Court in the DRC Uganda case. There the Court ordered provisional measures after finding that such rights might suffer irreparable prejudice. In our case, the sale of the building to a third party would create a legal and material impossibility of return. Mr. President, members of the Court, in addition, as you just heard, France owes an obligation to Equatorial Guinea to cooperate and assist in returning the building in accordance with the Merida Convention. This obligation, too, is central to the Convention. Article 51 obliges states parties to afford one another the widest measure of cooperation and assistance. There would be no point in cooperation, and indeed no cooperation, if the building is sold. In that case, the building would be removed from the control of both parties. In summary, to allow the sale of the building to proceed would be to accept that one party may unilaterally deprive the court's future decision of effect. A decision on the merits in Equatorial Guinea's favour concerning return and cooperation would in fact be impossible to implement, and the judgment would be a mere declaration of principle. We have already explained how the French Loi de Programmation of 2021 works and what it mandates France to do after the sale of the building. France will proceed to decide on the use of the proceeds of the sale. In effect, it will unilaterally decide on their use, thereby arrogating to itself the power to decide how the public funds of a third state ought to be used. This would be in clear violation of the principles of sovereign equality and of non-intervention in the internal affairs of other states, which are expressly protected by Article 4 of the Merida Convention. In summary, the prejudice would be irreparable because it would make the right to return of the property under the Merida Convention impossible, and it would render illusory France's obligation of international cooperation to that end. And, to add insult to injury, it would be a grave violation of Equatorial Guinea's rights to sovereign equality and non-intervention in its internal affairs, which the states parties to the Merida Convention have expressly sought to protect. Mr. President, members of the Court, I now turn to the requirement of urgency. The Court has referred to this condition in the following terms in several orders on provisional measures, and I quote, urgency in the sense that there is a real and imminent risk that irreparable prejudice will be caused to the rights claimed before the Court gives its final decision. I emphasize, before the Court gives its final decision. To demonstrate urgency, it must be established that, and again I quote, the acts susceptible of causing irreparable prejudice can occur at any moment before the Court makes a final decision in the case. In the present case, Equatorial Guinea does not ask you to speculate on future hypothetical risks. We are well beyond that stage. The acts susceptible of causing irreparable prejudice are no mere possibility. They are the logical and declared outcome of a deliberate policy by France, applying its own law and ignoring the Merida Convention, and I might add, ignoring the proceedings before this court. France's acts in this regard have recently undergone a dramatic acceleration, and despite our invitation, France has thus far failed to give any assurances that would eliminate the risks. Mr. President, the dispute before you, of course, is not new. From the outset, France's intention was clear. On several occasions, both before and after the institution of these proceedings, the highest French authorities have indicated that France did not intend to return the building to Equatorial Guinea, but rather to sell it. For example, in a letter to the President of the Republic of Equatorial Guinea, dated 21 June 2021, the President of France said, and this is my translation, assuming that the Cour de Cassation upholds the decision of the Paris Court of Appeal of 10 February 2020, which of course it did, the asset would become the property of the French state. It would then be put up for public sale in the months that follow, in accordance with the French legislation. That's what the President of France wrote. Similarly, Agrasc, the agency of which you've heard, wrote to the occupants of the building on 29 July 2022, and again I translate that, in application of Article 707(1) of the Code of Criminal Procedure, Agrasc is charged with executing this judicial decision and must therefore proceed to the sale of this asset. Mr. President, France seems to think that it can fulfill its obligations, its international obligations, on the basis of its loi de programmation and its own development policies. This position is baseless, not least because the French domestic regulatory framework in fact permits or even requires France to act in a way that is inconsistent with its international obligations to cooperate and to return the assets. This same regulatory framework requires the generation of proceeds arising from the disposal of the confiscated assets. France must sell the building to carry out its unilateral development actions. I would recall that already in January 2023, Equatorial Guinea informed this court of its auctioning of certain movable property seized from within the building. Far from pausing, France has accelerated its plan for the sale of the building. You've heard about some very recent events which demonstrate an intention to sell. On this, I can refer you to the factual account given this morning by Maitre Chikaya. He mentioned the request of a grasc to the President of the Paris Judicial Tribunal in late May 2025 to appoint a commissaire de justice, or, as you said this morning, an enforcement officer, or as I think we'd say in English law, a bailiff. He referred to the decision of the tribunal to accept that request at the beginning of June, and in execution of that decision, you've heard about the intrusion into the building on 18 June with all that has followed. He also described the exchanges between Equatorial Guinea and the French Foreign Ministry, which did nothing to resolve the urgent situation. In short, Mr. President, France is now taking concrete steps towards the sale of the building, which could happen at any moment. And there is clearly a real risk that this will happen before the court renders a final decision in the present case. I would recall that Equatorial Guinea is to submit its reply by the end of this month. France's rejoinder is then due on 28 May 2026. A judgment on the merits is therefore unlikely to come before sometime in 2027, and it could even be later. Mr. President, and here I apologize to the translators because I'm going to say a few things that aren't in the speech as they came up late yesterday. Mr. President, members of the court, the agent has already spoken about the bundle of documents we received from France late yesterday afternoon. It appears from Annex 5, which Maitre Chikaya showed you, in that bundle, that France may argue that it could be at least 18 months before the building at 42 Avenue Foch is sold. It is not clear in this document when the 18 months would start. In addition, the timelines are all tentative, and in any event, there's no guarantee whatsoever that they would be maintained. I note that Annex 5 is an undated document, though it is said to be a version à jour 2025. It has at the top the symbols of the French Republic and of Agrasc, but other than that, its status is unclear. It's signed by the head of Agrasc's land department. It appears to have been prepared specially for our case. In any event, it is in no sense a binding assurance by France that reduces in any way our concern that a sale may take place ahead of a final decision in the present case. Indeed, as Maitre Chikaya has explained, Annex 5 describes a series of intrusive steps leading to a sale, many of which have already taken place. Mr. President, if it were the case that no sale could take place for at least 18 months or longer from now, why, I wonder, would France not be ready to give appropriate assurances that no sale or other irreversible steps would take place before a final decision of this court? Mr. President, the same regulatory framework requires the generation of proceeds arising from the disposal of confiscated assets. France must sell the building to carry out its unilateral development action. Sorry, I've jumped back a few paragraphs, I apologize. Mr. President, the ultimate proof of urgency lies in France's attitude since the intrusion into the building of 18 June of this year. On the very same day, Equatorial Guinea protested these events by way of a note verbale. France's response on 19 June 2025 was as laconic as it was revealing. It confirmed the facts while stating its wish to be able to find a solution in accordance with French law and international law, without, however, offering the slightest guarantee that the process of sale would be suspended. Faced with this response, as you know, Equatorial Guinea contacted the Registry of the Court on 24 June, requesting that France provide formal and unequivocal assurances that it would refrain from any action likely to cause irreparable harm, and in particular from selling the building for the duration of these proceedings. France's only response has been silence. You will recall, Mr. President, members of the Court, a recent case which showed the importance of legally binding and fully satisfactory assurances being given by a respondent state. Such assurances, provided they are in the right terms and unambiguous, can make it unnecessary for the Court to issue provisional measures. I'm referring, of course, to the Mexico-Ecuador case from last year. Conversely, however, the absence of clear and binding assurances, indeed the deliberate failure to provide such assurances, can only reinforce the conclusion that there is urgency. In the present case, Mr. President, members of the Court, we would be looking for a clear commitment by France that it will take no further steps towards the sale of the building situated at 42 Avenue Foch and restore unimpeded access thereto before this Court has issued its final judgment. The urgency for issuing provisional measures in the present case is established by a number of factors. First, the recent and dramatic acceleration of the preparatory measures for the sale, culminating in the physical takeover of the building on 18 June. Then a long-standing intention on the part of France to apply its loi de programmation of 2021, which, as we've seen, is inconsistent with the Merida Convention, and the lack of assurances from France. Mr. President, members of the Court, I now turn to the second part of my statement, more briefly, in which I shall explain the provisional measures that Equatorial Guinea seeks today, and the link between these measures and the rights whose protection is sought. Mr. President, members of the Court, you'll find the three requested measures reproduced at tab UV in your folders, but you probably know them by heart, as we do. Mr. President, Equatorial Guinea submits that there is a clear link between the first measure requested and the plausible rights Equatorial Guinea seeks to preserve while the case is pending. This measure, which is of central importance for the effectiveness of the present proceedings, would enjoin France from proceeding with the sale of the building at 42 Avenue Foch. The measure is of central importance because, if the building is sold, as I've explained, France will no longer be able to return it to Equatorial Guinea, which is the chief right we are seeking to uphold in bringing this case. As my colleagues have explained, Equatorial Guinea maintains that it is entitled under the Merida Convention to the return of this asset and to cooperation and assistance from France in this regard. The sale of the building would undoubtedly frustrate the possibility for Equatorial Guinea to enjoy these rights, which are the heart of the case. The first provisional measure requested, by its very nature, is aimed at protecting these rights. Mr. President, Equatorial Guinea next requests the Court to order that France guarantee to Equatorial Guinea immediate, complete and unhindered access to the entire building. This measure too has for its aim maintaining the status quo existing at the time when the dispute was brought before you in September 2021. As explained by earlier speakers, until early in the morning of 18 June, Equatorial Guinea had full and unimpeded access to the building and was using it as a matter of course for government non-commercial purposes, to use the language of the UN Convention on the Jurisdictional Immunities of States and their property. This access was impeded by virtue of the intrusive steps taken by France on 18 June as part of its unlawful process of selling the building, precisely those steps that compelled us to come before you today. Ordering France to ensure Equatorial Guinea's continued full access to the building, pending the Court's final decision, would be consistent with guaranteeing that France will not proceed to sell the building. Like the first measure we request, this second measure would cause no significant harm to France. Mr. President, the third and final measure requested by Equatorial Guinea would require France to refrain from any act that might aggravate or extend the dispute or render it more difficult of solution. The Court has, of course, indicated such a measure on several previous cases, directing it at one or other party or even both. It is precisely this kind of aggravation that France is engaged in at present, by invading the building on 18 June 2025, by changing the locks, by taking control of the premises. France is committing an act of coercion which would have a direct and immediate prejudicial effect on the implementation of the Court's eventual decision and would aggravate and extend the dispute. So the third requested measure is appropriate, indeed necessary, in the present extraordinary circumstances in which France has refused, in fact, to provide to Equatorial Guinea precisely this basic assurance, so far refused. France has been unwilling to rein in either the courts or a grasp. It seeks to defend its inaction by reference to the independence of these organs, though of course the conduct of national courts and state organs is attributable to the state. France has already auctioned off property belonging to Equatorial Guinea and is now moving to make use of the funds unilaterally to promote its own interests in accordance with its domestic law. Continuing to do so would certainly extend or aggravate the dispute. Mr. President, members of the Court, I thank you for your attention, and I now ask Mr. President to invite the agent of the Republic of Equatorial Guinea, His Excellency Mr. Carmelo Mvono Nga, to the podium to present Equatorial Guinea's final submissions. I thank you.
I thank Sir Michael Wood for his statement. I now give the floor back to the agent of Equatorial Guinea, His Excellency Mr. Mvono Nga. You have the floor, sir.
Señor Presidente.
Mr. President, members of the Court, you've heard the members of our delegation who have demonstrated that all the conditions necessary for the indication of provisional measures are met. I would like to recall, especially, the absence until today of any assurance by France to Equatorial Guinea, assurances that could alleviate our deep concerns that the French authorities do not respect their international legal obligations. We invite France once more to offer such assurances during its presentation this afternoon. I also recall, respectfully, that on the 18th of June, while France was adopting unilateral measures in relation to the case now pending resolution before this Honourable Court, the Republic of Equatorial Guinea, on the contrary, decided to act with a maximum of constraint and institutional responsibility. Moved by its deep respect for this court and its commitment with the principle of good faith in international relations, Equatorial Guinea responded with measurement, dignity, and full observance of the norms of international diplomacy, abstaining from any action that would affect the integrity of this ongoing judicial process. This attitude not only shows the respect that our state professes for the principle of peaceful settlement of disputes, it also reaffirms its firm willingness to submit itself to the judgment of this high tribunal and to fully cooperate with its mandate. France must remember that it is the International Court of Justice who decides. That is why we appear today before this Honourable Court with the firm purpose of explaining the facts as they occurred, with transparency and respect for judicial process. On the 18th of June, the agents of AGRASC attempted to occupy a building belonging to Equatorial Guinea without previous authorization, without our consent, and in the absence of our official representatives. Such an act constituted a direct, arbitrary, and non-consented intervention in the property of the state of Equatorial Guinea. Equatorial Guinea categorically rejects this way of proceeding, reaffirms its commitment to international law, and trusts fully in the impartial judgment of this court to re-establish the respect that is due to our sovereignty. Equatorial Guinea rejects this way of proceeding, as I have said, because no one could believe that France could, on its own territory, humiliate us and disrespect our sovereignty, symbolized by our flag. This is why I reiterate once more to the delegation of France that the dignity of our state is untouchable. Untouchable as a symbol of the sovereignty of Equatorial Guinea. I must now, Mr. President, read out the final submissions of the Republic of Equatorial Guinea. On the basis of the arguments exposed above, Equatorial Guinea asks the court to indicate, in accordance with Article 41 of its statute, the following provisional measures. A. France must take all the necessary measures to prevent the building from being put on sale, the property. France must guarantee Equatorial Guinea immediate, complete, and unimpeded access to the property. C. France must abstain from any act that might extend the dispute or deepen the dispute that is before the court, or that might make its resolution more difficult. Mr. President, members of the court, this concludes the presentation of Equatorial Guinea. On behalf of our delegation, I thank you for your attention. I also wish to express my gratitude to the registrar and his team, as well as to the interpreters, for their work during these proceedings. And finally, I thank the French delegation for its attention, and especially its agent. And to conclude, I would like to thank the delegation of Equatorial Guinea for its professionality and for its attention. Thank you very much.
I thank the agent of Equatorial Guinea, whose statement brings to an end the single round of oral argument of the government of Equatorial Guinea, as well as this morning's sitting. The court will meet again this afternoon at 4 p.m. to hear France present its single round of oral argument. The sitting is adjourned.
Teman-teman, terima kasih banyak telah menyaksikan siaran di channel YouTube Manuskrip Papua. Kami sangat menghargai setiap dukungan yang kalian berikan. Tanpa kalian, perjalanan channel ini tidak akan terasa seistimewa ini. Salam dan hormat dari YouTuber Manuskrip Papua.